At this time, I would like to welcome everyone to the Compliance Point Compliance Year-End Review in 2013 forecast. I will call over to Danny Hitt. Danny, the floor is yours.
Thank you, and good afternoon, everybody, and thank you for joining. This is Danny Hitt, Senior Business Development Manager for Compliance Point. Thanks for being on the line with us today as we present the 2012 Compliance Legislation Review and what's on the horizon for 2013. We bring this presentation to you to make sure that everyone has guidance in this complex area. I'll end the presentation today by sharing the credentials of our speakers with you. Kessler is the Vice President and General Manager of Compliance Point and has more than 30 years of leadership and management experience and thousands of hours of process engineering and consulting expertise under belt. Over 12 years, Ken has helped dozens of companies craft compliance manuals, understand legislative rules, build compliance processes for their marketing programs, and order and enforce compliance throughout the enterprise. The Compliance Point team have performed hundreds of compliance assessments, safe harbor reviews, audits, and third-party compliance certifications. As with all Compliance Point consultants, Ken holds the certification for Certified Information Privacy Professional. Ken is involved with the Professional Association for Customer Engagement by serving on the National Board of Directors, as a trustee for the Self-Regulatory Organization, and as a certified PACE Self-Regulatory Organization auditor. Next on the agenda, we have Nick Whistler. Nick is an attorney for the law firm McMurray, Peterson & Schuster. Practice focuses on assisting clients in highly regulated industries complying with federal and state consumer protection laws and regulations, with a special focus on compliance issues affecting contact centers. Nick is a certified information privacy professional and currently serves on the legislative chair of the PACE Ohio Valley chapter, and also is a co-author of the PACE Do Not Call Regulatory Guide. Now I'd like to hand it over to Ken so we can kick off the webinar.
And thanks everybody once again for attending. I see a lot of the names there are very familiar to me on the attendee list. A lot of friends there and folks we've been working with for many years. You know, we do this really at the beginning of every year to kind of update everyone on what we've seen out there at federal and state. And for the last couple of years, we've had the pleasure of partnering with our go-to law firm that we use, McMurray, Peterson, Schuster. Nick Whistler is certainly one of the resources that we use a lot, and we certainly would recommend them to you. And we thank Nick for joining us today. So we're going to get right into the presentation, talk about a bit about us, a little bit from 2012, the regulatory occurrences that have happened, as well as what we have learned from some of the enforcements and settlements have occurred last year. And then, as the operator said, we always try to save some time for Q&A at the end. I think a lot of you know us very well. We see a lot of customers on there, but certainly, as Danny indicated, we do a lot of there in the field. I guess what I would say to kind of just give a general description of what we do, we're really operationally focused. We're very comfortable in the call center environment at the corporate headquarters, understanding and seeing what's going on and helping companies implement the kind of regulatory requirements that law firms like Nick certainly provide to you as well. So that's really what to do, our strong point, I guess. And right now, I'd like to ask Nick to talk a little bit about his law firm. Nick?
Yeah, Ken. Thanks for having me on. Just a little bit of background about MPS and what we do. Founded by 3 assistant attorney generals from the Ohio AG's office and a former Attorney General, Betty Montgomery. So the firm, we're all worked in the Attorney General's office under the Consumer Protection Division and have a significant amount of experience kind of on the other end of what a lot of you folks are doing, which is trying to comply with these regulations. They're on the side trying to enforce them. So that's a little bit of background about the firm itself. We do a lot of work in the telemarketing area, as you may expect, a lot of privacy stuff as well. Basically, our practices include any type of area that involves to consumer interaction. You can see the list here. I'm not going to go through all of them, but types of services that we provide are compliance type of issues, whether it's state surveys on applicable laws, legal opinions, setting up compliance programs, doing legislative and regulatory monitoring for companies. G relations is another area, so we'll proactively work with state attorneys general to kind of get a company out there and build relationships with them before problems arise. So representing folks with matters that are pending before a state AG or a agency such as the FTC or FCC, so working on a subpoena response or some type of investigation or lawsuit there. The last thing is that our firm serves as general counsel to a number of associations, most notably probably you folks would be PACE, formerly the ATA. So.
Okay, I'll dive right in here. So if anyone has questions along the way, just jot them down or think about them, and we'll be sure we try to get to those at the end of this. You know, obviously 2012 wasn't much different than other recent years. It did bring several changes in the laws and at the state level. And we're convinced that these changes are being brought about by a lot of innovations in technology, a lot of social networking, social media issues. Even the economy is having a big impact on new regulations because of some of the things that companies have done in the downed economy to consumers that have gotten them into trouble. And of course, there's always an influence from the European Union because of the global marketplace pressuring the United States to have tougher, more stringent rules and regulations. So I'm going to jump right in here, a little bit about what's happened here at the federal level. This is very interesting. Every year the FTC publishes a data book, and if you're ever interested in it, it has a lot of good information in it. They publish this as kind of a year-end review of what's occurred, and I've given you the link there. Interestingly, we're now over 217 million phone numbers, 7 million more than we had in 2011. Complaints have increased quite a bit in 2012, up to now 308 million from 203. And really interesting here to me is we see every year a decrease the number of companies that are actually paying for a subscription to the National Registry. You can see here in 2006, remember the registry was about 3 years old then, with about 7,000 companies, and that's just in half now today in 2012. So what does that tell you when we have fewer and fewer companies purchasing the registry? Tells you that a lot of companies have stopped telemarketing altogether. Other companies have limited what they do to perhaps their existing customers. Robocalls continues to be a source of many complaints. I can tell you that last year when we were at the PACE Regulatory Summit in Washington, D.C., we heard the Federal Trade Commission speak about things, they're kind of their hot buttons, and one of the very first things they talked about was going after that are still doing robocalls despite the requirement to have the consumer's prior express consent. Also talked about the fees going up again. You know, we had a couple years where the fees stayed the same to access the registry. Now effective October of last year, it has increased a little bit. Basically, it costs an additional about $400, $450 now to access the entire registry. This is new this year. This is going to be a requirement anybody that's buying data. This public safety answering point do not call registry is really another do not call list or do not call registry that some companies need to be aware of, because essentially this list is going to contain all of the facilities in the U.S. that are for public safety types of facilities, emergency rooms, police, sheriff's departments, those kinds of things. And of course, with any new list, there's going to be a host of accompanying regulations about, the prohibition to call those numbers, use automated telephone dialing system, and so on. And so this is an emerging thing. If you're only calling customers, you're calling consumers who have inquired and provided a number, this is not such a problem. But again, if you are purchasing data from any sources, we highly recommend that when this is finally becomes a requirement, that you access that. And Possible Now and others out there that provide these kinds of list suppression services, they will be a resource when this list becomes available. So you can see here some of the penalties they have listed here. Probations, you're talking upwards of $100,000 per call. Pretty serious about it. This is not effective yet. This will be published in the Federal Registry once it's approved by the Office of Management and Budget. You'll see a Federal Registry notice. We'll only send communications out to everyone, and then at the same time we'll get instructions about how to access this, how to actually perform the suppressions. They have a 31-day. You have to access it once every 31 days, similar to the National Do Not Call Registry. So some of the other updates under the FCC. I know a lot of you on the phone have heard a lot about this change to the FCC last year, and it's now rolling into this year. There was the FCC 12-21 amendments. There was a final rule published later in June of last year. The OMB published its final approval on October 16th of 2012, and that's really what got the ball rolling on all these changes. And we're not going to spend a lot of time on each one of these, but these are the primary changes in this. Effective October 16th of this year, so we now have, about 8 months or so and counting. The new express written consent requirement effect before making any solicitation calls to mobile phones using an automated telephone dialing system, as any pre-recorded messages to residential numbers as well as mobile phones. Will be effective October 16th. Now, again, this is very problematic. It means that there has to be a very explicit consent that is agreed to. A statement something like, checking this box constitutes my agreement to receive a solicitation telephone call using an automated telephone dialing system at the mobile phone I've provided above, something like that. We are going to give a very detailed webinar on this subject, and we're going to talk about all the ways that you can actually gain this consent through mail, email, inbound call, web form, hard copy documents. We're going to discuss all of those vehicles, all the record-keeping requirements, talk about some strategies for you to collect this on February 14th, and I'll remind you again at the end of this, I have a slide that kind of talks about that. Abandonment rate calculation changed a little bit with this. This is already in effect since November, basically 3% per campaign over a 30-day period. It used to be 3% over all campaigns, and so they have tightened up a little bit. It's got to be per campaign. And then there's the issue of the automated opt-out requirement for any abandoned call and this requirement also is included now in any delivery of a pre-recorded message, you also have to have this automated opt-out requirement that the person is able to, for example, recording comes on that says press 1 now to be automatically added to our do not call list. Went into effect just a few days ago, about 2 weeks ago of this month, the requirement. Now remember that these requirements are only effective for calls that are subject to the call abandonment prohibitions. So if you're making calls that are not subject to call abandonment requirements, then this does not apply.
Yeah, Kerry, point if you don't mind, if I'll jump in here.
Sure.
We're getting a lot of questions from regarding whether the call abandonment provisions and the opt-out requirement therein apply to calls in the B2B space, so calls to a business. And it's a pretty interesting issue. One thing would be a pretty easy, but it was actually a little bit more complicated than that. There's no express B exemption across the board under the TCPA or the FCC's regulations that implement the TCPA. So whether a rule in the TCPA applies to business-to-business calls depends on what specific person it is. Some are limited, for example, to calls to residential numbers, others not. So the call limit rules apply to any telemarketing call. And to go with the definition of that is it's defined pretty broadly. It's not limited to calls to residential numbers, calls to sell consumer goods, for example. So the call abandonment rules do apply to B2B calls. Where it's interesting is this whole concept of providing an opt-out right. So, the reason that's in there is to allow consumers to press 1 or do whatever to be added to your do not call list. Well, these do not call rules do not apply to B2B calls. So it's kind of counterintuitive that you're allowing them to press a button to be placed on your do not call list for a B2B campaign when on the back of that there's really no B2B do call list. So we actually reached out to the FCC on this issue, kind of explained our predicament, and what we're hearing from the staff level people, so this is staff attorneys at the FCC, not the commissioners themselves. Staff people said that based on the way the rule's written, they think that it applies and you need to provide this for B2B calls. So it seems kind of, like I said, counterintuitive, but I would say there's going to be a risk associated with not providing this during a B2B campaign.
Yeah, Nick, and you reminded me of something else too. I want to be clear when we talk about the new express consent requirements for calls to mobile phones. These are only relevant to calls that are placed using an automated telephone dialing system or an auto dialer. And I would caution all of you, there are people who think you can, preview mode or you can, manipulate the dialer in some way as to avoid the use of an automated telephone dialing system. But, the courts have very broadly applied the definition of automated telephone dialing system. And, I would be very, very cautious in trying anything like that. Unless you are actually picking up a handset and finger pressing the numbers into a keypad, you could be potentially using an automated telephone dialing system according to some court. Now, this new rule, this new high level of consent will not apply to service calls that are not solicitations, reminder calls, service calls, shipment calls, payment calls. That the old standard of the party provided you the number will suffice for those non-solicitation calls. Again, we're going to go into great detail on all of this on February the 14th when we have a very deep dive on this whole issue.
Can I want to interject here, if I may? What an ATDS is, what an automatic telephone dialing system is, as you alluded, it's very specific, and how a court is going to interpret that is a little bit gray. We can go based on what DC has said and what courts have already said, et cetera. But the only thing I'll interject here is that we have been asked in the past to give opinions regarding a specific filing process, and is it subject to the TCPA because it is an ATS, or is it not subject to that provision because it's not? So that's something that if you guys want more help with, that we're happy to provide that. Take a look at what you're doing and whether we think it falls within the scope of the prohibition or not.
Thanks, Nick. Here, we just wanted to show you something that we'll make available to all of you because this is getting quite complex. And so what we've done here at Compliance Point is how to develop some quick and easy references, or what we're calling decision trees for do not call compliance. This comes with a guide. There's a full guide that has all these areas here: state, national, wireless, specific, as well as non-exempt and exempt types of calls. And we're not going to go through all of these. We don't have time, but this is essentially what we have. This campaign is a non-exempt cold call, so this is, purchased leads, for example, that aren't inquiries, new data, things like that. And so what this tree does is walk you through the decision matrix to determine, should I handle the call? Is the number on our internal list? No. You ask the next question, is it on the federal list? No. Is it on the state list? No. And then you walk through this whole tree down to individual states here in an attempt to determine how to handle that particular type of campaign. Again, this is not something to be used as legal advice. It is a good guide to get you further down the road to understanding the questions you might need to ask. The other similar one for an inquiry exemption that goes a different tree. This is a regular inquiry EBR situation. Also developed one for the traditional transactional EBR, federal and state law. You can see here there are some states, for example, that only allow 6-month dialing, 12-month dialing, so we've incorporated that into this. One thing that we'll do when the new prior express consent standard does take effect later this year, we will revise this to include those new standards. And finally, this one is subscription-based. This is current customers, that you have an ongoing relationship, contractual relationship with, different tree for that. And if anyone's interested in this, let us know. We have the guide, a full guide that goes with it, and we'll be happy to send all this to you for use as for your attendance here today. I'll just look at some of the real quick here because I want to make sure I leave Nick enough time to get through the state things. This is really the FTC chairman issued recently the Commission's annual highlights. And we always review these closely because always a lot of good information in here, and you get insights into what's going on in the mind of the FTC for upcoming initiatives. Certainly this one had a lot of privacy in it. Privacy issues, again, we feel are being driven. New technology that's available, as well as influences from around the world, us to tighten up our privacy requirements here in this country. Really, privacy by design. This initiative, as most of you know, is a requirement that whenever you build something and implement something, that through every step of that design, you incorporate privacy measures and privacy considerations. Everybody wants greater transparency. They want you to clearly inform consumers how you're using their data, how it's being stored, who it's being shared with, and so on. More choice about those things. And then they also announced a memorandum of understanding with China, as well as an agreement on best practices with the EU. There's a lot of things going on here that they're fighting. This last dollar fraud has to do with the economy that we're in today. There's been a few companies out there, credit repair and, those kinds of things that have really garnered the attention of the Federal Trade Commission. Talked a lot about the new technology that's driving a lot of problems, and the FTC is attempting to keep up with the pace of technology so that the regulations accommodate these things. And finally, they are cooperating and collaborating with the Consumer Financial Protection Bureau, which as you know, is a fairly new bureau that's been put together, and they'll have a memorandum of understanding between these agencies to share more information, coordinate enforcement, and try to have consistent policies between these organizations. I'm going to go through all of these. These are some of the examples that the FTC gave of showing how they were protecting consumer privacy. These are some of the companies, the things that they uncovered. A lot of these were settled and never got to court, but as you can see, there were some significant settlements as well, and you can see some of the issues that the FTC was tracking and got involved with. This was the initiatives that they're showing how they're fighting these initiatives in economic times. A lot of judgments here, a lot of settlements as well. Big time dollars, $29.8 million there for the grant case, $36 million for a major U.S. bank situation. And so, yes, they are very active, and it's always a good idea to be aware of these things so that you are aware of how they might apply to some of the things that you may be considering. Robocalls, once again, I'm really surprised anybody is still doing these. I mean, it's clear that you have to have a very high level of consent to do these. In the beginning, the Federal Trade Commission several years ago ran up this requirement while the FCC still had an exemption for EBR calls for these robocalls, and of course that changed this year with the new TCPA amendment. So right now, both FTC and FCC are in alignment here that you must have a very high level of consent for someone to receive a solicitation pre-recorded message. And we've also seen not only the companies that are sending the messages, but the providers of these messages. The technology providers have been brought into the purview of the FTC as well. Last bullet's kind of funny. The FTC is trying to figure out how can we, what technology can we put into place to identify these bad players, to stop these robocalls, and actually offered a $50,000 bounty to anybody who can come up with the best idea to help stop these robocalls. And this just recently closed, so maybe we'll hear something shortly on some of these initiatives. Again, these are examples of some of the companies that have gotten into trouble with robocalls. Lots of money involved here in terms of risk. Nowadays it's just not something you want to do for any solicitation campaign. It just doesn't make sense. Here are some of the federal actions. Again, many of you may have heard of some of these, but it's the robocall thing again. Timeshare, we hear a lot about that every year, timeshare resales. And once again, debt relief operations. Lots of companies in the trouble with that. And we know from speaking with the FTC and we know from watching what they do, there are certain types of complaints that really elevate the potential of an investigation. You might have 100 or 150 do not call complaints sitting on the books, but it may not take very many complaints at all about consumers saying they feel they've been ripped off by a debt relief operation or a phony timeshare thing. It doesn't take very many of them to get the attention. Okay, we went through that very quickly, and now I'd like to turn this over to Nick and let him talk about all the things that have been going on in the States. Nick?
Thanks, Ken. So yeah, I think what we're going to do here is just kind of go over what we saw in 2012 in terms of legislation and enforcement, and of what we saw, and maybe a little bit of what to expect in the coming year. So I just kind of want to go through some of the common themes that we're seeing in terms of legislation and regulations. On this, but these are probably the four most common types of bills and regulations we're seeing. First has to do with any type of strict messages or calls to cell phones. And there's a few different varieties of these. The first is you've got these laws that have been on the book for years, and most of them were written before cell phones may have been around, or at the very least before they became so prevalent, definitely before text messages were around. So they're kind of going back and changing definitions of terms and changing the scope of the law so that they explicitly apply to the types of communications. And the second is just an outright prohibition against sending unsolicited text messages. We're seeing bills introduced that have that type of content. That may not be of surprise to you, which is pre-recorded messages. These from you need to have consent to, if you send them, you need to meet certain technical criteria. To a lot of them, and likely because 2012 is an election year, but more political-oriented bills were introduced regarding political calls. That ties into the next topic. So we've got political calls, pre-recorded messages being one. One other ones that we're seeing are do not lists for political calls. So political calls don't apply to political calls right now, but we're seeing some states introduce stuff that would have a DNC list for that. The last is caller ID. Those state laws that are kind of mirroring what the FCC did to implement the Truth in Caller ID Act. Some of them that go a little bit beyond that, and the reason the very bottom line, intent to defraud. So when we're looking at caller ID legislation, we're looking to see, okay, is there a provision that applies to any type of manipulation of caller ID, or is it really only problematic or prohibited if there's an intent to defraud? With our language is written. I'm going to quickly go through a few bills that were passed. So these are bills that are now law, or soon will be law once the effective date kicks in. First is in New York. A lot of you may be familiar with this. Basically what it did is adopted pre-recorded telemarketing sales rules that mirror the FTC has, and soon what the FCC will have as well. So you need written consent for those. They're also imposing automated opt-out requirements that what the FTC has. These are pre-recorded telemarketing sales rule or sales calls. Big change was the registration. So you were exempt from registration as long as you were licensed or registered in any state agent, with any state agency. So that could be just be incorporated in a certain state, or registering with the Secretary of State, or something very simple like that. Basically did was they kept the exemption, but now you have to still register, but you're exempt from the fee and bonding requirements. So you do have to fill out some paperwork and send it to the state. And the change had to do with record retention requirements, and they imposed some 2-year record retention requirements that mirror what the FTC has. To effect in November. For those of you maybe that rely on that exemption that haven't already back and registered, it's something that you'll probably want to do here shortly. A few things that we're seeing, there's a Missouri bill here that was passed that is kind of the one I talked about earlier, where it's expanding the scope of the law to cover cell phones and text messages. The other big change here was that the do not call list now includes cell phones. And as you can see, there's a up there about the number of Missouri residents that added their cell phone to the list within a short period of time. And the other thing that's important to think about here is Missouri actually, the law actually automatically incorporates numbers on the federal do not call registry. So any cell phone numbers that were already on the federal registry now get incorporated by reference. I'll share quickly, Wisconsin had a bill that also expanded their laws to cover text messages. Florida is no longer charging consumers to put their number on the do not call list. There's a few other changes in that bill, but that's probably the most relevant. Georgia had a caller ID bill that was passed. It does go beyond what the federal law does, so it's really just talking about blocking or preventing information from being displayed. There is a private action which is notable. Bill, so this one's a little bit interesting. It prohibits the transmission of inaccurate or misleading caller ID information, and misleading can be interpreted a few different ways, and there's no intent to defraud language in that statute. So it actually is a little bit broader than what the law says and what the FCC's regulations say to implement that law. Kind of the bar I'll say here is there was a recent Fifth Circuit Court of Appeals opinion that was analyzing Mississippi's law, which had similar language to what this Connecticut law has. And what this circuit ended up saying was the law was preempted by federal law because it prohibited more conduct. So it prohibited what they call non-harmful spoofing. It was basically this misleading language. Something could be inaccurate or misleading, but it could be done, for example, for debt collection calls, or it could be that you're doing some mystery shopping and you're using the caller ID information for there. Basically said is if there's no intent to defraud, so harm associated with it, it's this law cannot prohibit that conduct. So interesting cases for the Fifth Circuit. We can see if other courts and other circuits kind of follow suit on that. So now we're getting into some legislation that was proposed. Just keep in mind as we go through all these is that we just turned from 2012 to 2013. So the vast majority of states, all but maybe two or three, their legislatures did at the end of last year, and so a new one begins this year. What that means is if there was a law that was previously proposed, it's at the end of the session, and they have to reintroduce it. That being said, the reason I want to kind of go through some of these is just, again, to kind of see what was introduced last year, and more likely we're going to see very similar bills introduced this year. In fact, a lot of state legislators will reintroduce the same exact bill the next year and try to see if they can make it further towards passage that year. So Louisiana bill that's listed here, with restriction on text messages, some type of prohibition. The reason I say probably is because basically what it does is it directs the Louisiana PSC, which is the Public Service Commission, to adopt rules. So it didn't have rules specifically outlined in the bill. That would be up to the agency to this would be. The Mississippi bill that's listed here, it would take do not call list and apply it to text messages and faxes. Again, it's kind of expanding the scope of the previously written laws. Kind of what federal rules do, which is basically treat those types of communications the same as a call would be treated. This Massachusetts bill was interesting. It prohibited what they called robocall telephone solicitations. And why I say it was interesting is because it actually included text messages within the definition of robocall. So, they're not distinguishing between a pre-recorded message and a text message in that context. Applied pretty liberally, including charitable solicitations, political calls, and contests. Express exemption for consent or EBR. So, very, very broad prohibition. Again, they're just bills, not laws. Here's some specific to, also specific to calls and texts. Bill and a Senate, New York Senate bill. Again, I'm not too much time on these just because aren't current bills, and because we'll talk a little bit moving forward with what you're going to see in 2013. Again, going back to our four main points at the beginning, pre-recorded messages and political calls. Here's a few examples of those types of bills. The Michigan bill is notable because it created a DNC list, and the Massachusetts bill was basically just a prohibition against a pre-recorded political call. I think people were fed up with all the political pre-recorded messages that were inundating people in 2012 and as well, but anytime you have a pro campaign and a lot of in-house campaigns, you're going to increase of those. And here's a call deregulation. This one is active, so it's a regulation, not a bill, so not a law. We can carry over from one year to the next. And interesting as well, so it prohibits misleading or inaccurate caller ID information, pretty similar with the Connecticut law that we just talked about and the Mississippi law, in that have intent to defraud language. So I have more information on this one. Our firm actually represented a client who was interested in this regulation. So Schuster, one of the firm attorney here, went to the Wisconsin Department of Agriculture, Trade and Protection, and with them, and basically said, and this is all kind of informal guidance, so it's not in a written opinion or anything like that, but they basically said that their interpretation was more in line of what the federal rule is. So they're looking for it to harm that type of conduct, not just a non-harmful mission of caller ID for whatever purpose, maybe like the use of a local area code or something like that. They weren't so concerned about that. Again, informal stuff from them, but that's what they told us. So here, I wanted to go through was a Arizona bill. Basically, what it would have done is taken the marketing registration exemption that currently exists for professional fundraisers and kind of narrowing it so that only the charity itself would qualify for that exemption. If you're a professional fundraiser calling on behalf of a charity, the exemption would not apply. The status says, again, the bill did carry over from 2012 to 2013, but I did leave the status up here just kind of so that it actually passed the House and went to the Senate. And what that means is that there was a decent amount of support for this, and I would not be surprised to see the bill or a similar bill reintroduced in 2013, given that it did have some support and it couldn't pass in both houses. So for 2012, from the legislative perspective, seeing the first month of 2013, a lot of the same stuff. Text messages, big issue. Cell phones, recorded messages, also big. Bill would increase fines for do not call violations. I think there's a sentiment out there that people are violating do not call laws because they're concerned about the penalties. I've seen some criminal penalties being associated with these laws. More call laws are being introduced. I think one that I'm seeing more of this year than I had in the past are bills that would restrict the location of a call center in some way. And there's different ways, different types that I'm seeing. The first would be if you have a call center located in the United States and you are relocating it overseas somewhere, there's certain notice requirements that you would have to meet. You'd have to notify the state, and you would have to advance notice before you actually moved it, and there would be certain repercussions associated with that. Maybe that you're not eligible to receive funds from the state, for example, those types of things. The second type is states are award their call center contracts to third parties, and what they're saying is that you are a company that has call center located overseas, that you will no longer be eligible to receive state contracts. Interesting topic. You know, it's surprising considering the focus on job creation and job retention, but something to keep an eye on. The only specific bill I'm going to talk about is this Mississippi bill here, and it's just because we're getting inundated with questions on it. and rightly so. There's some pretty harsh provisions in this that would limit call attempts that you can make to a consumer to one, unless either A, they call you back, or B, you have some type of EBR with the consumer. So think about that. That's obviously a very problematic provision. The second would be you can only call from 2 to 4 p.m. local time rather than whatever current time is. I'm guessing something like 8 a.m. to 9 p.m. Is probably what it is. I'd have to verify that though. And then the last is caller ID. This is basically the same one that's already on their books, and it's the same one that was invalidated by the Fifth Circuit. So this specific provision isn't problematic because you have that nice case law. But the first two big issues, and interesting to see if there's any support whatsoever in the legislature for that, and whether it starts to move forward or just kind of languishes and doesn't move. Actions go. I'm going to go through these real quickly as well. It will be available for those of you who want the slides later to go back and take a look at in more detail. But Arkansas noted a increase in the amount of do not call complaints getting, and they're questioning the effectiveness of the DNC provisions. Their AGs or assistant AGs are encouraging residents to file complaints. So what they're saying is, we can't go after these people unless you ping to us. India, as you know, is pretty aggressive with DNC enforcement. We had a $10,000 fine to a company sending text messages to Indiana residents. This one's interesting. They've basically they haven't changed anything in their legislation, but they've kind of that they are interpreting their statute as not requiring a marketer to disser. So somebody that's strictly performing services on behalf of a third-party seller does not need to disser. It's only the seller itself, unless an exemption applies. There's a implementation of its own law. North Dakota continues to be aggressive in terms of percentages. Mississippi's been really active in terms of enforcement. There's a $5.7 million fine here for an Arizona company that was violating the do not call laws. Same thing here is that they failed to respond to the complaints that were forwarded by the C, and so wisdom is that if you get some type of complaint or letter from a state regulator, you have to respond. You cannot just think it'll go away. It's the worst thing you could possibly do. Mississippi enforcement, $1 million for DNC violations. As case law goes, there's a plethora of case law out there. I'm just going to go in a few of them today, but things are constantly changing. The thing to keep in mind with case law is that each court has its own jurisdiction and only needs to follow rulings of a court that's above it. So, for example, at the federal, a district court has to follow whatever circuit it is in. So, any type of case law, it's important to note, but don't just assume that that is going to be the standard that's applied across the board. That may not be the case. So there's a John's case. This one was involves a different concepts here. Happened was a bunch of franchises sent out text messages for one vendor, and the facts indicate that the vendor presented to these franchises that you could send it out with an EBR rather than consent. And what the court is saying is that it would not dismiss Papa John's from the suit. It basically said that John's, the actual company, could actually be held liable for the conduct of these franchises. And it applied the class action, meaning it's going to allow the class action to move forward. There's $250 million in damages. I highly doubt it'll be anything near that, but I would not be surprised to see some type of settlement in the multi-million-dollar range. Essentially, this whole theory of liability for third parties is also what's been at stake in that Dish Network case that's been pending for quite some time. So to take away here is that if you are working with third parties, they are violating the law, you can potentially be held liable for that unless you're doing a sufficient amount of due diligence to make sure that they are in fact complying with the laws. So another case here is a federal case in Alabama that involved Walmart. Actually, is a good case for the industry. It upped the FCC's prior ruling that somebody provides you with their telephone number, express consent to be contacted at that number unless they tell you otherwise. I will note that we're talking about the express consent as is currently in the TCPA. When written consent requirements are imposed, just provision of a cell phone number is no longer going to be sufficient. There has to be specific disclosures made and it to be documented in specific ways. So what is a good holding is going to be somewhat irrelevant for purposes of telemarketing calls come October. And the other important holding was that they kind of said that to call somebody is the same as consent to text them. So what happened was they were sending text messages and they said, okay, we don't have consent. Well, they sat down and then they said, okay, well, if you had consent, that was only consent to make a call, it was not consent to make a text. And what the court said is the FD and courts treat calls like text messages in terms of you have to have consent in the first place, and you can't require this, additional level of consent for a text message versus a call. If you're going to treat the same in one context, you have to treat them the same in the other context. So that was a good ruling for the industry. In this case, basically, the takeaway here is that if you are calling somebody who did not provide you with their cell phone, that's not consent, so you can't get it from another source. And I think that's the end of the state updates. I know I went through those very quickly. I could answer questions on any of those. Again, the slides will be made available when we're done, but wanted to make sure we got through everything. And Ken, I think I'll turn it back over to you.
Thanks a lot, Nick. We're getting near the end here, so here are just some of the lessons that we've learned overall through 2012. We know that, he said that the beginning of all things bad is when consumers complain, and consumers complain about legal calls. And so always think about this when it comes to the efforts that you put forth to have a defendable position. Even though you know that you're suppressing properly, you're keeping records, you're obeying call abandonment, you have a good program for scripting adherence and all those things, just realize that you're going to get complaints anyway, even from people who never pick up the phone, who don't know why you're calling or who you are. You're going to get complaints. So always have a defendable position to show that you're obeying and that you intend to comply, and it'll put you in a much better position. We always advocate as well some strategies that you can think about to reduce the likelihood of those complaints through scripting, reminding people why you're calling, reminding people who you are, if there are inquiries, reminding where they inquired at, so on. Again, robocalls, I think we've tried to be very loud and clear today. Not a good plan, not a good strategy for solicitation type calls. We need to be looking elsewhere to deliver those messages because the consent standard is extraordinarily high. The last point is kind of one that Nick talked about. If you do receive a notice of complaint or an inquiry of any kind from any federal or state entity, this is something that you need to pay immediate attention to. If it's a serious civil investigative demand, you want to, hire an outside law firm that has dealt with this stuff before and knows what to do. You want to assign a senior officer in your company to be in charge of doing the evidence and making sure that you respond in a timely way. In other words, it is a significant event that costs you a lot more money if you don't take it seriously. So our conclusions, again, we've talked about a lot of these already. We do know that there is an ever-changing regulatory environment. Every time there's a new technology, every time almost there's a new app for an iPhone or something that comes out that causes another issue, it's going to cause a new regulation. So we were telling everybody, consider how to get strategies for opt-in right now today before the new requirements take place. If you're buying a lot of leads from lead generators, lead aggregators, web lead sources, there's going to be a huge problem after this new express consent standard takes place unless you can be assured that two things have occurred. One, that consumers have agreed to the proper disclosure as discussed, and number two, that the consumer has given that consent to your company. Understand that your company is the one that's going to be calling them. Without those two things from lead aggregator sources, you don't have what you need to be placing solicitation calls to mobile phones using an automated telephone dialing system. The change takes effect. So here's the conclusions. We know that everybody needs to be thinking seriously about having a preference management strategy because it is the wave of the future. Because of these tough consent laws, wireless SMS, all of these things going on, the new tougher laws for pre-recorded messages. And we do have some quotes here from some of the prominent sources around the country that believe, for example, that all marketing will need to be permission-based by 2020, and this is from the American Marketing Association. So if you're not collecting consumer consent now, it's something that, or consumer preferences, it's something that you certainly ought to consider for your future. I want to introduce today, we are here at Compliance Point, we're launching a Trusted Seal program. It's a compliance trust that we're hoping that you'll be interested in earning for your company, for your call centers, for service bureaus. For the webinar for this, that date is incorrect on there. It's actually March the 7th, Thursday, March the 7th is the correct date for the webinar. We're going to talk in detail how the program works and how you can use and benefit the seal. There's a lot to the program. We're very proud of it, and we've been asked about this by many, many clients to have a program like this so that companies that are compliant companies can broadcast this seal on all of their websites, all of their emails, all of their marketing material to show their customers, their businesses that they're working with, that they are a compliance trusted partner and a good player in the industry. So there'll be a lot more about that on March 7th. We'll send out the webinar invites for that. Again, our next webinar will be February the 14th. And that one is the operational compliance with the new TCPA. That's where we're going to, in detail, describe all the different ways you can collect consent, what the statements have to say, strategies, an entire hour dedicated to this issue will be provided on that date. So as of right now, I'd like to turn it over for questions. We had some questions come in. And I've answered quite a few of those that came in over the web here, but we're certainly happy to take any phone questions as well.
If you have a question, please press *1 on your phone. Again, that is *1. To a web question, locate the Q&A panel, type in your question, and click Send to submit. We'll pause a few moments to compile the Q&A. And do we have any audio questions?
No audio questions at this time.
Wait, let's give people a few seconds.
question, please press star 1. Madam, are there any questions?
There are no questions at this time.
Thank you.
Okay. Well, if you think of questions.
I see a question that's in the online. I'll just answer verbally. It'll probably be easier than me typing in a response. But the question was, how does the FTC find out if a call is generated using an auto dialer or manually? They probably wouldn't know initially, but what they would do is issue some type of CID or a subpoena to request records from the company, and they basically ask for whatever they want, with exceptions. So it would not be that difficult for them to find that out. And kind of a related note, to calling cell phones manually, the thing I'm telling them is private plaintiff or a class action attorney is probably going to assume that you are using a dialer or some type of auto dialer. So be prepared to have to defend yourself. So be prepared to get some type of complaint, possibly even a lawsuit that says, hey, you called these cell phones, we think you used this type of technology, and you'd have to have a way to show, no, we didn't, we did it this way, especially if it's a company that has both predictive dialing capabilities and then has a separate manual dialing process. You have to show that the call came from that manual dialing process, not from the predictive dialer or other type of auto dialer that you're using.
Thanks, Nick. Answering some of these online here as well. Again, if anyone is interested in the charts that we showed, just email me. I have my email address up here on the screen. Shoot me an email, and we will get those charts to you. I have a question here from Jacob Farrer. Is using a local caller ID for the market which you are calling considered intent to defraud?
Yeah, I did answer that on there, but for those of you who didn't see that, no, it's not. It's actually specifically brought to the attention of the FCC when they were making their rule, and they were requesting an exemption for that. And basically what they said is you don't need an exemption. That's not prohibited unless you've got some type of intent to deceive or to defraud, meaning the underlying purpose of what you're doing is to wrongfully get something from the consumer, to defraud them in some way. So no.
Question, I'm a debt collector in New Jersey and I have a predictive dialer. How does the abandonment requirements affect my company?
It doesn't, largely. So that the call abandonment provisions apply to telemarketing calls. A debt collection call would not fall within the definition of telemarketing, so they would not apply.
Okay. Questions before we end the call?
Question from Mike Salerno.
Okay, go ahead.
Hi. Could you clarify what you earlier said about bond inquiries from third parties with regard to the clarification of the person to call?
Yes. October of this year, the ability to call a consumer using an automated dialer, their cell phone, solicitation, and this is even if they've inquired, if they're current customers, after that date, you have to have first obtained that person's explicit, private and express consent to receive that solicitation call. And so the concern in the industry is, as of today, when you're buying a lot of your inquiry leads from web sources, lead aggregators, and so on, a lot of companies are just receiving a data feed. They'll get a file, and it'll have the information in it, the name and number and so on, but would not have the evidence in a situation like that you need as the entity making the outbound call to prove that the person agreed to the disclosure and affirmatively indicated that their agreement. So that is the issue for the industry. How do I buy those leads and confidently call mobile phones? how do I know that that person knows and agreed to my company calling them? And how do I know that they have, in fact, consented to me calling their cell phone with this new standard?
Okay. The effective date again is?
October 16th, 2013.
Applies solely to mobile phones.
Well, not only mobile phones. That same standard applies to pre-recorded solicitation messages to landline phones as well after that date.
But if not pre-recorded, again, only applying then to live phone call to a mobile phone is what's, in other words?
A live solicitation or recorded solicitation call to a mobile phone using automated telephone dialing system. A manual dialed call would not be subject to that prohibition requirement.
Thank you.
Any final words?
Don't have any unless there's any more questions.
Thank you, everyone, for joining today. We had a very good attendance. And once again, if you want copies of the information that we're provided, shoot us an email and we'll get it out to you today. Thank you so much, and we'll see you on February the 14th.
Thank you. That concludes the conference. You may now disconnect.